Welcome to Graves Thomas Injury Law Group podcast. I'm Joe Graves, and today I'm here and joined by my law partner, Matthew Thomas. Today we're breaking down personal injury protection law, commonly called PIP, because this is one of the most misunderstood parts of Florida auto insurance. Most people assume the at-fault driver's insurance pays first after a crash. In Florida, that's not how it works. Your own insurance pays first, and the rules surrounding PIP can dramatically affect your medical treatment and your legal rights. Today, we're going to explain how Florida PIP actually works, the most common mistakes people make after an accident, and what every Florida driver should know to protect themselves. So, when we talk about PIP, Matthew, it's called a no-fault statute. And I hear the word no fault misused. People say, oh, it's a no fault state. And I don't think they really, I see the context online and it's not, it's misunderstood. What is no fault?
Just means that it doesn't matter who's at fault for the accident for your personal injury protection or PIP benefits to begin. So those PIP benefits, which is strangely in Florida, it's one of the only types of coverage that's actually required. PIP and property damage are the only two that are required for automobile cases. A lot of people think bodily injury liability insurance is required, but it's not. And PIP will apply for the first portion of your medical bills up to $10,000, regardless of whether you're at fault for the accident or if someone else is at fault. So if you you run into someone who's stopped at a red light because you weren't paying attention and you're hurt, your PIP's going to be the first to pay for your medical bills, even though you're at fault for that accident. And just like in this scenario, in the reverse, that car that was sitting there that didn't do anything wrong, that got hurt and went to the medical doctor because of those injuries, their PIP is going to be paying first, even though they weren't at fault. So that's what it means, that there's no consideration of fault or responsibility for or liability for the accident for PIP to start to kick in from your own policy. Typically, there are exceptions to that.
Yeah, I think that's the first thing people ask or they don't understand. Actually, when you're in an accident, your PIP becomes primary for your medical insurance or Medicare or whatever it is. In a lot of hospitals, is astounding still. There becomes confusion in their billing process, like who are they to bill? But they're required to bill the PIP first because it becomes primary. Then once the PIP is exhausted, once that $10,000 is exhausted or used up, then your health insurance or Medicare should kick in. But let's talk about the $10,000 coverage. How much does that pay of the medical bills?
I guess it depends on the type of medical treatment, but I mean, if you look generally across people who get into automobile accidents, because that's where PIP applies, and they're going to hospitals, I mean, I don't think it's a major secret out there anymore that hospitals are overbilling. I mean, healthcare in America, specifically in the hospital context, has become extremely expensive. And so when you go to a facility after a traumatic event, such as an automobile accident, and PIP is being applied, it's going to get eaten up and used by the medical facility almost immediately. I mean, typically you can see bills at hospitals now for full diagnostic testing and maybe, some blood work. I mean, you're talking about, it could be up to $20,000 in total charges. I mean, that's going to use up that PIP, that $10,000 on day one.
Yeah, I think most people think or don't understand that PIP only pays 80% of the medical bill.
That's right.
And they pay 80% of what the insurance company deems to be reasonable. So the insurance company, and it's 200% Medicare rates. So the insurance company will take a bill, take a look at it, apply this. It's in the statute now. The 200% Medicare rate, that's the statutory rate, and then reduce that bill to what or it could even be further. They'll look at the codes that are processed and whatnot, and it could be a fraction. It just, whatever. I mean, I've seen it all across the board in 34 years of practicing law. Sometimes it doesn't even make any sense. It'll pay 80%. Also will pay 60% of your lost wages. But like you said, if you go to the emergency room and really don't have any treatment at all, that PIP is going to be gone. And so now if you can't work, that potential recovery for wages is going to be gone as well. So, um, I think those are things that people don't really understand about, the priority of payment and how much it pays. It also pays a death benefit. If there's a death, that pays $5,000 in a death benefit. But I think a lot of people I've heard from clients, well, I get the $10,000. No, the medical provider bills the PIP insurer, and then the PIP insurer decides what's reasonable based on a statutory rate. And then that's what they pay directly to the provider.
Yeah, and let there be like no confusion about it. Personal injury protection and PIP was created and implemented by the legislature, not for our benefit. Okay, this is for the benefit of the medical providers, specifically hospitals. So I just think that's important to note, because there are ways that you can get wage losses, but if you're submitting your bills and there's available PIP under wages, you're not receiving dollar for dollar what you've received as a lost wage. There's going to be a curbing of that just because of the limited nature of the benefits. And then also the fact that they're associated with the same PIP that goes towards your medical benefits too.
Yeah.
Or expenses.
I don't know if I mentioned, but it's only 60% of your lost wages. So it's
Yeah.
not dollar for dollar. But within the statute, the medical provider says, hey, well, this isn't reasonable. You owe me X. What happens then?
In the scenario where there's, I guess there's like a balance billing, is that what you're referring to?
Well, it could be balance billing, which isn't allowed. But
Right.
I'm also talking about like when an insurance company looks at a bill and then they reduce it significantly to what they deem to be reasonable, but it's less than what the provider thinks is reasonable or calculated. Actually, the statute allows, for the insurer will then defend you from any collection attempts from the provider. So that's what I was getting at. Sorry if my question wasn't clear.
No.
But on the balance billing, it's a good question too. They're not allowed to balance bill.
Yeah.
So if they're billing PIP, then they're subject to the reasonable rate as determined by the insurer. You are going to be responsible for the 20%. But they can't balance bill. So I mean, I saw an emergency bill the other day. It was like $76,000, and it wasn't that significant of an injury, but it was, they did every testing under the sun. And that's what I think you're seeing in a lot of the emergency rooms now. They're doing all these tests, and they're just taking that PIP because they want to get the entire amount of the policy. And it really becomes problematic for someone, especially if they don't have health insurance, to be able to get further treatment, if they're injured. I think there's a couple things, and I just want to mention that, this is a discussion generally about PIP and PIP law in Florida. We're not intending this to be legal advice, but just a general discussion about the topic. One of the things that the legislature keeps whittling down on PIP benefits.
Mhm.
A few years ago, they excluded massage therapy and
Yep.
people like acupuncture. It's
Yep.
not covered.
Yep.
But you need to treat within 14 days of your accident.
Yeah.
I see the cases that we have, and, our clients generally aren't ones that are like calling from the accident scene. They're generally ones that like they had an accident and they thought like they were sore or hurting, or, this is going to go away. Then they do some research, they find us, and, then it ends up being something significant. They had the soreness, had the problem, but, in the PIP law, if you wait past the 14-day period, then you're going to forfeit that $10,000.
That's right.
And so, that's just something to be aware of. If you're in an accident, auto accident, and your PIP applies, so it could apply, in a bicycle accident, you could apply it as a pedestrian.
Yeah. And I mean, it goes back to exactly what I was saying, which is, that these laws, PIP laws, and I mean, comparatively for the audience out there, I mean, there's other states that have PIP limits of 100,000. Okay, so Florida has 10,000, just to give perspective about comparison of PIP laws. Some states don't even do PIP. But that being said, in Florida, um, there's no science behind the idea that if someone doesn't get treatment in 14 days, that they weren't hurt. Okay, that is a number that was picked out by the insurance companies because they thought they could sell it to the legislature, and they did. But you're right, it is the law. So if you don't go within 14 days and there's something called an emergency medical condition that can be assigned by a doctor to preserve your PIP benefits within that time. But if you don't go within those 14 days, oops, you've waived your PIP. Even though you've waived it, that is that you don't get the benefits of your PIP because you didn't treat in that 14 days. If you do end up having a lawsuit against the person who caused the accident, ultimately, if you go to trial and you get a judgment or a verdict against them, that verdict is still offset or set off by the PIP. That means that whatever the verdict is, there's another 10,000 that's removed generally from that verdict because of the PIP availability, even though you never actually got those benefits. So yeah, the first 14 days, kind of a random date to use by the legislature, but it is the law in Florida. So you got to get it. You got to see a medical provider within that 14 days to preserve those PIP rights.
That's true. Another thing to keep in mind is your initial benefits are $2,500 until and unless there is a determination of an emergency medical condition. That's exact language from statute. How does that affect your PIP benefits after the $2,500?
And it's just another little hurdle that they put into the statute to try to create some sort of way out for the carriers to pay. But yeah, you're right. The first $2,500 is there. But if you get a emergency medical condition determined by a doctor, which it doesn't seem like it's very difficult for people to get, but you do need that in order to get those additional benefits. And at any time, your carrier will, and they routinely do this, require you to go to be examined by one of their medical professionals that they've hired, who oftentimes are routine hirees of the carriers, and they will deem your medical treatment or future medical treatment unnecessary or excessive, and therefore try to cut off or limit your PIP benefits. I mean, that can't happen. It happens a lot.
Another obstacle to getting the benefits that you actually have paid a premium for for years. Just to recap, you have to treat within the first 14 days. You're limited to $2,500 until you get an emergency medical condition opinion. And then on and only after that, you get access to your full $10,000 in coverage. And it's interesting you bring up the independent. They call it independent. It's not independent. I mean, these are doctors or a chiropractor or whatever medical specialty it is that's hired by the insurance company.
They have no doctor-patient relationship with the insured.
Yeah. So when insurance companies, it kind of takes a broader topic. And I was thinking about this today when I was walking my dog. I think that's a distinction that people don't really appreciate, because at a trial, you may see this doctor who looks very legally qualified or educationally qualified or have a ton of experience. But the true distinction is, and you brought it up, is there's no duty to that patient. So if that doctor's wrong or that doctor misdiagnoses, there's no obligation, there's no remedy for the patient. And so really what the trick is, and I think it's a trick after, doing this for so many years, is that when you have a doctor-patient relationship, so you go to your doctor, your treating doctor, you give them a history. You tell them what's wrong with you. That's a subjective history. The subjective history plus the objective evidence. So it could be an X-ray, it could be an MRI, something you can see, touch, or feel objective. And that's how you render the diagnosis, right? But if the insurance company hires a doctor that has no legal duty to the patient, they cut that subjective history right out. And then it'll say that how many times have we seen this in a report? There's no objective evidence of an acute injury, right? And you can't make a diagnosis. I mean, if there's a fracture or something like that, yeah, maybe you could make it solely on objective evidence. But you have to understand, you can't. So even with a fracture, how would you know when that happened unless the patient's telling you when it happened? Or how would you know what the problems are unless the patient's telling you, and then you investigate as the doctor who has a legal duty, right, to an obligation to that patient. That's what insurance companies do, and they'll do it in PIP cases because they want to cut your benefits off. They want to, it's like going to the mechanic. You find a really good mechanic that fixes your car, charges you a good rate, it's reliable, gives you what you want. You go back to that mechanic, right? Or whatever specialty it is.
I call them jukeboxes. You put the money in and you tell it what song to sing, and then that's what it
But it's
does.
basically the same thing. So if an insurance company is looking like over this spread of doctors, but you go to the phone book that shows my age, but you go on Google on your phone, you look the number of doctors. How is it that they choose this particular doctor? And I say and submit that it's like going to that good mechanic that's going to give you what you want and give you the product that you want. And that's the people that we see. We don't see a variety of doctors. It's not like it's random. It's the same doctors in every case that are used. And I submit because they're giving the opinions that benefit the insurance company. And this is just part of what you're up against in an accident case.
Yeah, I think the reason we all trust doctors, like on a general sense, is because of that thing they call the Socratic oath. And the doctors take an oath to for their patients and for the administering of medical and healthcare to their patients. Well, if you take away that dynamic, that is that the doctor is no longer treating a patient, the Socratic oath really doesn't apply. And because they're not actually practicing medicine at that point, because they're not practicing medicine on their patient, because there is no patient. They're just there giving in a medical opinion for an insurance company. And I think that's critical because it takes away, the foundation of trust that is the reason that people do trust these medical providers, which is that Socratic oath, which they no longer have to follow if they're not treating a patient and providing medical care.
Yeah, I think for the clients that I see, and I'm sure you've had a similar experience, people have a certain level of trust if they've never been involved in something like this before. They feel like, maybe they've been a policyholder with an insurance carrier for 10, 15, 20 years, and they have this feeling that the insurance company is going to look out for their best interests. The number of times that I've heard people say, I'm really surprised that my insurance company is taking this position, or I'm really surprised that my insurance company is doing this.
Yeah. Well, and the insurance companies are definitely pushing that narrative, right? Uh, like a good neighbor, State Farm is there. You're in good hands. They're all terms and sayings that are generally trying to perpetuate the narrative that the insurance company is trying to do right by their insured. But at the end of the day, it's a business, and that business is collecting more in premiums than you pay out in claims. So I think that dynamic of insurance is critical to appreciate when you're talking about fairness or honesty or um, I guess just responsibility under contracts or agreements with insurance companies.
I often get asked, well, why do I need a lawyer? And these are some of the pitfalls that you can fall into, or some of the things that can happen, and it becomes really an overwhelming process. Um, when I think from the perspective of the client, you're trying to get treatment, you're hurting, and you're trying to get your bills paid. You see these bills, these gigantic bills that are coming in from the hospital, and then you're wondering, well, how's this going to get paid, and so forth. So, um, that's part of what we're trying to address here today. So I think you covered it in Florida. Personal injury protection is required along with property damage to get a license tag. So property damage coverage covers someone else's property damage. If you're negligent and you hit them, it covers their property damage, doesn't cover yours. PIP is required by every Florida driver, and the reasoning and the rationale for PIP when it was first legislated was to make it easy for injured people to get treatment without having to prove fault, because sometimes that can take time. Um, people get frustrated in a property damage can't claim because maybe their insured's telling them the accident happened a different way, or maybe there's some evidence that sometimes it takes them a little bit of time to, agree to fault. Um, the only way we can make them do that is through a lawsuit, which is, takes time. So th- it's one of the obstacles, I think, and one of the reasons why PIP was legislated. There has been and have been some bills. There was a bill, I believe, last year that actually passed through the legislature to do away with PIP,
Yeah.
and it was vetoed.
Vetoed.
Yeah.
Shocking.
So I mean, we got to understand that like these companies are like multi-billion-dollar corporations.
Putting it lightly, yeah.
Yeah, I mean they are making money
Yeah.
and then um trying to deny benefits at the same time.
Yeah, and I think that insurance is a really great thing. Okay, the concept of it, that someone's protected, that there's money there. I tell people all the time, go out, get insurance, make sure you're insured, because medical expenses, life is difficult, but as lawyers, specifically because we have a unique exposure to it, I think it's critical that we keep the insurance companies in check, because absolute power corrupts absolutely, and the insurance companies have become so powerful and so um, financially strong that they can influence politicians and influence legislation, and do it in unique ways, whether it's advertising, news programs, or just passing bills. And so I think people need to appreciate that. And if you look, even historically in Florida, we were passing laws back in the 70s and 80s warning people in the preambles, Joe. Insurance companies are trying to take advantage of you. They're going to try to take as little as they can each time, or as much as they can in little bites each time, until they get you in a place where you become a slave to their system. And we're getting away with these preambles. Like somehow insurance companies have like turned the corner, and now they're, acting altruistically for the benefits of the citizens. And it's just not the case. And I think people need to understand that, because that checks and balances of the insurance company and regulating the insurance company is the only way to keep them in check, in a system that, let's not forget, folks, is mandatory to have. You can't drive on the road without insurance. So they've already made it a mandatory type of institution. It's just, what are the coverages that are mandatory? And they want to make mandatory the coverages that benefit them, not benefit you. That's why your uninsured motorist coverage can be waived, because they want it to be waived, because that's a benefit of coverage towards you, the actual consumer and insured.
So I'm going to go over some questions that, were posed to us about this particular subject.
Okay.
So, the first one, what does PIP insurance cover in Florida? I think we've covered that. It becomes primary after an accident. It covers 80% of your medical bills at the reasonable rate. The 200% Medicare is the ceiling, and 80% of that is paid by PIP. There is another coverage called MedPay, medical payments coverage, that covers the additional 20%, but it's an optional coverage. It's not something that's required. Some people have it, some people don't. It's always good to have, I think,
More coverage is always better. I think, MedPay can apply in certain situations and become useful. No doubt about it.
yeah. It also covers 60% of your wages, as we've discussed. There's a requirement of a 13-week wage statement that you would get from your employer. You submit it, and that's how you get your wages paid, if there's any PIP after your emergency room visit or walk-in clinic or wherever it is that you go. for treatment. And remember, you have to treat within the first 14 days. Treatment it's limited to $2,500 unless you get an emergency medical condition opinion, which would generally be handled by your provider. And then you're entitled to the full $10,000 of benefit. I think we already discussed this too. This question is, how does Florida PIP insurance work after a car accident? It becomes primary. So before your health insurance or your Medicare or whatever insurance that you have, your PIP pays first. And then once your PIP is exhausted, your medical insurance will kick in. So Matthew, do you need a lawyer to file a PIP claim?
Technically, no. PIP claims can be filed, automatically if you go and your PIP is paying for your medical treatment right away. But what I would say is those are the early stages where it's a much better decision to go out and get one. People trying to handle it themselves, I think, can routinely find themselves. I mean, if you're still with us here on this podcast right now listening, I would say you probably already fully appreciate that this is not the most clean cut, easy type of issue. That's why we get questions about it all the time, by the way. It's definitely important to hire a lawyer to help you with that. But I suppose theoretically, it's not required. Although I think a smarter client would.
Is a person entitled to sue after a car accident if they have PIP?
Sure. Of course. Yeah. PIP doesn't impact the right to sue. It may impact how and what claims you can make against your own insurance company for failure to pay your PIP, or maybe they wrongfully deny you with PIP. Those types of things can come up where you can make have a certain requirement for suits against the carrier. But if a person causes you damages, and they don't want to agree to pay you the amount that you believe is fair and reasonable for your services or damages, then yes, you can sue and file a lawsuit.
Matthew, in your experience, what should a person do immediately after they've been injured in a car accident?
Immediately after being injured in a car accident, I mean, and this is a loaded question in a way because I want people to really understand that if you're really hurt in an accident, focus on getting better and then immediate care. Like, life is short. I want people to be healthy. I want people to talk to their families and get medical care, even when they're unsure about whether they should or not because of these PIP type issues and the cutoffs that, if you're kind of hesitating on that, it can really have a backfire for you if you realize later that you really are hurt. That being said, to the extent someone can help us collect evidence, I love that. I love people that clients that if they're in a space to be able to do it, or maybe they have a loved one who can do it, whether it's photographs or collecting witness information. You think the law enforcement's going to do that, but they have so much going on their plates that sometimes maybe when they're doing an accident investigation, they don't do the most thorough job, and that's not fault against law enforcement. That's just because they're dealing with so many accidents on a daily basis and calls for service that sometimes they can miss things. So I do like clients when they can help put that together on the front end before they when they come here.
Can an accident victim choose their own doctor under Florida PIP law?
Yeah, absolutely. There's no law that requires PIP to control who you actually treat with medically. We talked about emergency medical conditions earlier. Those are required by MDs, so I guess there's some component of it. If you want to bill under PIP, you can't do anesthesia, acupuncture, exactly, acupuncture or massage anymore under PIP. You used to be able to. So in that sense, they somewhat control, I guess, if you want to bill under PIP. But no, you get to choose your own provider. You get to go to who you like and who you trust, and it's the way it should be.
Another question is, what injuries qualify for full PIP benefits? I mean, it depends on your injury. It depends on the treatment of the doctor, what the doctor's diagnosis is, what their proposed treatment is, and all that. But there isn't any particular injury in and of itself. It just depends on the severity of the injury and how much you're hurting and how much treatment that you need under the doctor's care. Um, if the insurance company denies a PIP claim, what then?
There is a process if a PIP claim is denied, and I want everyone to understand out there too that all these issues. We're here for you to explain this more in depth. If you're interested in it, we're giving you the highlights. It's a free consultation to any one of our clients who wants to get a little bit more information about these sort of things. So I want people to know that. Um, eh, but that being said, as it relates to getting that coverage in place, just going to the facility of your choice within the time frame, and then you see the doctor for that care, and they'll submit it to the PIP. And if that's denied, there's something called a PIP demand and a PIP lawsuit, which is just a formal demand made by statute outlining where the insurance company went wrong with that denial of claim. And if they don't remedy it or they don't fix it, you could sue the insurance company and routinely get attorney's fees actually in those lawsuits. So that makes it a little bit easier for people to deal with. So they're not having to, come out of pocket to pay an attorney for something that the insurance company did wrong.
Yeah, one thing that I talk to clients about, in a medical legal case like what we have, when we're representing a victim of an auto accident, treatment is important. Going to the doctor, right away, and then consistency of care, doing what the doctor says that you need to do as far as treatment, because it's a little bit different, than if you have an ache or pain and you decide, I don't want to mess with it or I don't want to go, because we have the burden of proof. We have to prove, and the client ultimately has to prove what their injury is, and also prove that whatever it is, that it's as a result of this accident.
Yeah.
So the only way we can prove that is through medical evidence.
Hmm.
So going to the doctor, giving that history, making sure that's documented in your medical record, making sure, and you may go to the doctor and like a couple days after an accident, your neck is really sore and that's your primary focus, but you got something in your shoulder or your knee too. Make sure you tell the doctor everything that is wrong with you or you're feeling, or it can come back and be used against you later on.
Absolutely.
I mean, in a litigation context,
Yeah.
tell us how that works.
Yeah. I mean, nowadays you go into a doctor and typically I think they like hand you an iPad and you're going to be filling out on this iPad all these different questions. And sometimes I think it's logical that a patient might go to the doctor for a specific ailment, and they're getting a 20-page docu-sign iPad that they're filling out information. And it's not that they're not being honest; it's that they omit information that they don't believe is relevant, or because they're focused on this. But what happens in a litigation setting is that the defense will try to use that against them to say that they weren't being completely candid with the doctor in those early moments. And so, one, I would say for people, be overly descriptive. Your life story is your story. If you've had a prior injury before, it's okay. It doesn't mean you can't be injured. So tell the doctors about what your medical history is, so that it's not something that you admitting it can be used against you later on. And in the litigation component, as it relates to just getting medical treatment, I would just tell people that everything can be used against you to some degree. You're always going to have the subjective complaints of your injury, that is how you feel. But people are skeptical of a plaintiff with no objective evidence. That's where the doctor's visits and the scans are. So collecting that, getting that, it makes your case so much easier to prove beyond just you needing a jury to rely on your statements. Yes, we want a jury to believe you. Yes, we want a jury to know you're credible, but it makes it a heck of a lot easier to be able to do that when you got objective evidence such as, doctor visit notes, MRI findings, and recommendations for future medical care too.
Can you touch briefly on permanent injury, the permanent injury threshold, and
Yeah.
the significance of that?
The first thing I'll say about permanent injury is you don't know what it means because no one knows what it means because it's undefined. There are certain, and I know there's probably a couple of lawyers out there. What about the AMA guidelines? Yes, there are guidelines that are out there written about what constitutes a permanent injury. Oftentimes there's an inflation with workers' comp because workers' comp will have a impairment rating system that's based on numbers. They try to use that in our setting to try to delineate whether a permanent injury has been incurred or not. But permanent injury really is a term that is undefined by the statute itself that requires it. But in Florida, it's called the threshold statute. You have to prove a permanent injury in order to be entitled to pain and suffering. That is, that if a jury, and they'll be asked in an automobile case, was the plaintiff permanently injured? Did they sustain a permanent injury as a result of the crash? And if they click no or check no on that verdict sheet, there's no pain and suffering that the court is legally allowed to award. So it's critical that they do check that box, yes. And in order to get that box checked, yes, you have to give your doctors the ample ammo they need to be able to support an opinion of a permanent injury, which again, it's a misnomer because it doesn't mean that it lasts forever. So I want everyone to understand that in the legal context, a permanent injury isn't something that needs to last forever. And if that's not confusing to you, I'm not sure what is, because technically 3 months of complaints of chronic pain to the same area of the body constitutes a permanent impairment under some AMA guidelines. So if you think about that, another little trick played by the insurance companies to, give you another burden of proof, another hurdle that you have to overcome in order to get, what you should be entitled to anyway. If someone causes you pain and suffering, you should be entitled to a permanent injury or not.
All right, last question.
Yeah.
From your experience, why do claims get undervalued?
I think the number one reason that claims, there's two top reasons, and they work in conjunction. One reason that the claims get undervalued is the insurance company wants to undervalue those claims. So they're constantly trying to undervalue your claim. That's how they achieve that ultimate goal, which I talked about earlier, which is pay out less in claims than you accept in premiums. But the other main factor that's working against, for instance, our clients with valuation, bad law firms. I think people are undersettling their case. I think people are going to lawyers who have maybe a gift for gab, but they don't really have the wherewithal or the resources to be able to handle these cases. And so they're setting a tone of a bad valuation that's being used against us. So that's something that I'm constantly frustrating defense attorneys and insurance companies on, because they're one, they say no one values cases like this, and then two, they say, I sure hope that you don't you don't continue to spread this to other defense attorneys, because we're routinely settling these cases with other firms for literally 50 cents, 20 cents on the dollar for what they're paying us. And so we have to fight that, and that's why I think they're undervaluing claims. It's the attorneys that are handling them, and then of course the dynamic of the insurance companies who just want to pay you less than what you deserve ultimately.
I'd like to add to that. I think from the client's perspective, what can the client do is, do what the doctor tells you to do. Don't have big gaps in time between seeing the doctors. They're going to use an argument. They're going to say, well, if you're hurt, you go to the doctor. If you're not hurt, you don't go to the doctor. So gaps between appointments, not following up, not following the recommendation of the treating doctor. Those are all these things can be added up, from the insurance company's perspective to devalue your claim. And they're going to use everything that they possibly can. I think one thing you hit on that I want to talk about just briefly, just because you may have had an issue before doesn't mean it can't be aggravated or worsened. In fact, the jury instruction, which we all look to, what would a jury ultimately do. That's what drives settlement. But the judge's instruction is basically on an aggravation case is try to separate it. But if you can't, then award for the entire injury. As we get older, we have degeneration. Our hair gets gray. Unfortunately, mine's getting grayer. Our spines degenerate. We have but it's a normal finding. But they try to make it like it's something that's like out of this world or extraordinary, and it's not. It's normal. People have degeneration as they age. That doesn't mean you can't be injured. In fact, I think it makes you more susceptible to being injured. A person my age is more susceptible to being injured in an accident than an 18-year-old who doesn't have degeneration, whose body is those joints and so forth are more flexible. So I think early treatment we discussed matters. Getting the injuries documented, seeing a medical professional early and making sure that you list all your complaints, consistency of care, doing what the doctor says to do. All this documentation becomes extremely critical in determining the value of your case and how your case is perceived by an insurance company or ultimately a jury at the end of the day.
Yeah, most people don't want to be involved in lawsuits. I mean, and understandably, the people that hire us are only hiring us because they're scared about the process, or they've been treated unfairly, or they just need a guide to get them through it. And I would say that not every case or claim that is signed up, or a client that we hires us, ultimately results in them necessarily even pursuing damages, because someone can have a full recovery very early on, and just say, listen, Matt, Joe, I've made a full recovery. I'm not interested in, collecting anything. And now we're 6 months out down the accident, and that's okay, because what we do is contingency fee based. What we do is we don't get paid unless you make a recovery. So if that happens, at least you protected yourself. But trying to think that you're not going to go through a lawsuit from the front end, that you're not going to make these claims on the front end, that's what the insurance company is hoping for. That's why they put the 14-day restriction, so that you somehow, believing that, although it turns out to be a mistake later, you've waived those rights. So, if you're in an accident, if you're feeling even slightly, hurt or injured, or you're concerned, please, I beg you guys to go out there and get that treatment right away. That's why you have PIP. That's why they sold it to us when we passed the legislation. So I think, it's important that we take advantage of that, and don't let those time gaps come back to bite us.
Yeah, and as you mentioned, we work on a contingency fee basis, so clients don't owe us any fees or any costs until we win their case. If a consultation is needed, maybe you have a question about your PIP benefits or your insurance coverage in general, no cost for a consultation to speak with us. We're happy to speak with our community, and if they have questions about insurance, to answer them to the best of our ability. In closing, I would say that if you're involved in a car accident, have questions about your Florida PIP law or your legal rights, contact Graves Thomas Injury Law Group. Understanding how PIP works early can make a major difference in protecting your health and your case. Thanks for listening.
Until next time, guys.